So we'll begin from Article 142. We have completed till 141. So this is the article for complete justice. This is very important. Okay, we shall see this in detail. So I have created a slide for it specifically. As we have already discussed, this court has the power. The Supreme Court of India has power to do anything regarding judiciary. But here we'll understand this power to pass decree or order is actually, or in terms of doing complete justice, will actually enable the court to correct legislative actions also. It is not specifically written, but this means it. Okay, how we will see the judicial developments also. Supreme Court as the supreme authority. They can even act against legislature when needed to do complete justice to ensure the right outcome. What happens is earlier India or judiciary in India was actually following the procedure established by law. They cannot correct the process, check the process. Okay, but now they can. But if you understand this Article 142, inherently this has that power of due process of law. Nowhere it is written that the Supreme Court cannot exercise. Yes, this has been a result of judicial developments, but if you understand this Article 142, it is having this power of due process of law. Because to do complete justice and to be able to correct even the flaws of legislature, this means that judiciary is absolutely using this principle, due process of law. If you do not know this, you can check out the previous video where I have explained the difference between these two concepts very clearly. Okay, they can even bypass the parliament to do complete justice. To ensure the right outcome, it can even ignore procedural laws. This was when it was followed procedure established by law. Okay, and very important thing is this, as in case of high courts, many of the powers that Supreme Court of India enjoys, the High Court also have, like writs jurisdiction, etc., or the Court of Record Philosophy, etc. But this power, doing complete justice, this is specifically exclusive to the Supreme Court of India, and High Courts do not enjoy this power. Okay, they do not come in picture also regarding this. Article 143, Presidential Reference. This is also very important. The president has used several times this. What happens is when there is a case involving certain, actually not a case, but certain decisions on which the president needs advice, where they will go. Okay, president will ask the Supreme Court of India for its opinion. Two things have to be understood because there is a usage of word may and shall. Okay, I'll show you. Okay, he may refer to the question to that court for consideration, and the court may, understand this, may, after such hearing as it thinks fit, report to the president its opinion thereupon. Okay, thereon. So the court may. It is not written the court shall produce its opinion. The court may. So in this first clause, that is 143(1), the court is not bound to give its opinion. But here in the second clause, if the president makes any reference regarding a pre-constitutional treaty, there is written the word the Supreme Court shall. Now they are bound. Okay, this is the difference which I wanted to show you, that this is often known as advisory jurisdiction. President can ask for opinion to the Supreme Court. One is that Supreme Court is not bound. They can clearly stay silent, okay, unless it's a pre-constitution treaty. There is one point also. The president is not bound to accept or follow the opinion of Supreme Court of India. Okay, this is just advisory. This is not recommendation as in case of collegium system, etc. This is just advisory. 144. Okay, this is a very important article. See this, I'll show you the text, then we'll come back at the slide. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. This article is actually giving teeth to the Supreme Court. Okay, without this article, the Supreme Court's judgment, decree, and orders remain just as opinions, because if nobody follows it or nobody is bound to follow it, these are just opinions. I have written the word state as well as judiciary because here the word used is civil all authorities, civil and judicial. Okay, this means all authorities, including the legislative and executive, that the government, parliament, government and legislature of state, and all the lower authorities, including the judicial, subordinate courts, the high courts. Okay, they will act in the aid of Supreme Court. Must help. The Supreme Court executes its orders. Okay, this is important because without this, whatever the Supreme Court says will not be executed. Let's see the 145. They have the power to regulate for its procedure. Okay, practicing before the court. This is clear. Proceedings in court, etc. How they will entertain the appeals, granting of bail. So this article is for rules and procedure in the court premises, what the court has to follow. This all power is vested in the court itself. Okay, this is nothing to be discussed. It is very much understandable easily. For minimum number of judges. Okay, this you can see. These are not the point to be discussed because these are just direct understandable things. 146 clause 1, appointments of officers and servants. Okay, this is about the staff. As in case of secretarial staff of parliament, they can have the power to recruit and regulate their services. So is the case with the judiciary also. They have the power to recruit and regulate their service conditions, etc. And also they have a lot of independence in this, and their salaries and allowances are charged upon the consolidated fund of India. Okay, this you can see. See, allowances and pension payable in respect to officers servants of Supreme Court shall be charged upon the consolidated fund of India. They are not to be voted upon in the parliament. Why this is done? To ensure absolute independence. In this chapter and chapter 5 of part 6, okay, this is giving a reference to the pre-constitutional laws as well as this, the Government of India Act 1935. What does this means is, maybe there are certain things which are left, and this constitutional interpretation also means the interpretation of the law which was pre-constitution, and India was governed according to this particular act, Government of India Act 1935. So this means this only, that interpretation of constitution also means interpretation of this act or other council acts, etc., etc. Now we will begin with the Comptroller and Auditor General of India, a very powerful body. Okay, constitutional post. Mostly the IS officers are, mostly 99.99% IS officers are the head of, become the CAG. Okay, we will resume this from the next video, so that the judiciary is in a different video and this starts from here. Okay, so thank you so much for the class. If you have any review or questions, feel free to comment. Okay.